Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the Antitrust section of the American Bar Association. My name's John Roberti. I'm the host of today's program, which is Who is Watching the Ads? The biggest mistakes and risks advertisers make that trigger investigations. Today, what we're going to be talking about is how advertising disputes and investigations come to be. We'll learn a little bit more about different types of investigations. There are investigations that are sort of basic ones involving fraudsters, middle market companies that just don't know any better. But there are also investigations that involve very, very sophisticated companies and competitors. And we're going to learn a little bit more about how these investigations come to be. My co-host today is Ricardo Woolery. Ricardo is an associate at the Skadden Arps law firm. He works in their antitrust group. Hi, Ricardo.
Thanks, John.
Ricardo, why are developments around figuring out where advertising disputes come from? Why is that important?
That's important because in our daily lives, we are all exposed to ads. Whether we're walking down the street or we're browsing the web, we see ads. You get exposed to ads. Some people say we get bombarded with ads. And it's important that these ads be truthful and these ads be accurate. And so, this is important because so one of the things we want to do is figure out, who are some of the regulators who watch these ads and make sure they're truthful and accurate, and what are some of the common mistakes that some of these companies make.
I'm assuming if you're a company, you're not excited to be on the wrong side of one of these advertising disputes.
I would imagine not.
Ricardo, who's our guest today?
Our guest today is Christopher Cole. Now, Chris is the co-chair of the Advertising and Media Group at Crowell & Morin, LLP, where he focuses on advertising, unfair competition, reputation, brand disparagement, and intellectual property issues.
And what do we want to get out of today's program?
Today, we want to figure out, what are some of the ways in which advertising sections of companies are organized? Do they have fully fledged compliance groups? Do they not? How does that impact the kind of risks they're exposed to? Who are some of the regulators? What are some of the tools they have? And really get into, some of the common mistakes that these folks make with an eye towards informing the public and informing those companies on how to avoid them.
Well, great. Let's bring in our guest. Christopher Cole, welcome to the program.
Thank you, guys. It's a pleasure to be here.
Chris, thanks for coming. So you have in your career, I imagine, done one or two of these investigations involving false advertising?
Absolutely. So we do the whole gamut. And when we think about advertising risk, we look at different buckets. You have on one side the regulators, which would be the FTC on one hand, the states, and there are 50 of them on the other. And then you've got private litigation, class action risk, which often follows a federal or state investigation. And then you have companies that police each other. So there's a lot of litigation company to company. Some of that plays out in federal court. Some of that also happens at the National Advertising Division, or NAD, as Ricardo mentioned.
So how is it these problems start? Is it a competitor that complains? Is it a consumer? Is it something else? How does that work?
All sorts of different ways. First and foremost, most problems with the regulators bubble up from consumer complaints. And companies would be very wise to watch what consumers are saying about their products. So, for example, the FTC has this database. They encourage people to go online and fill out a complaint form. They collect these, and then they look at trends, and then they bring enforcement in areas where lots of complaints are bubbling up. They call that Sentinel. States get complaints all the time, too. And they are looking to protect citizens in the various states. And, it's pretty simple. Lots of complaints in a particular industry or area, that's where the focus is going to be from a regulatory perspective. Now, the FTC and the states tend to look at fraud, and primarily financial fraud. So they're looking for really kind of abusive type behavior and going after that. They have limited resources, so they're trying to maximize bang for the buck. and they'll go after things where they think people are getting ripped off. Competitors, on the other hand, have a different agenda, generally speaking. They're a little less concerned about, I mean, it sounds cynical to say this, a little less concerned about consumer welfare, a little more concerned about, is what you're saying stealing market share away from me in an unfair way or a misleading way? So I think both of you guys are antitrust lawyers. Antitrust lawyers think about the proper functioning of markets, competition, and advertising is really just a subset of that. If the signals that are being sent to the marketplace are messed up and false, then people are reacting to improper signals in purchasing products, and the markets aren't functioning properly. So it really is aligned with competition in that sense.
Maybe we can break down a little bit what you just said, because you talked about the two different buckets. What does an advertisement look like that gets the FTC excited?
Well, that used to be an easy question. I would say 15 years ago and earlier, the vast majority of ads were this classic TV 30-second spot. You saw they had a little vignette for 30 seconds. There was a claim or two in there, and then maybe there were others that looked like that as part of a campaign. Now campaigns are multifaceted and multimedia. So you still have your 30-second TV ad. You have various lengths of ads. You have online video. You've got social media. You have influencers. Companies pay people to promote their products who have followings of their own. How did Kim Kardashian become so popular? I mean, she's got millions and millions of followers, and every time she tweets something out, she gets paid a large amount of money. For every 240 characters, she probably makes more money than any lawyer on earth.
I wish we could bill by the character and not by the hour as lawyers. But.
So in any given campaign, you have all these different levers that advertisers are pulling, trying to reach people where they are and different kinds of consumers where they are. The regulators, frankly, are very behind. They're trying to catch up with the evolution of media. Then there's digital media. So they're putting ads, sending ads to you based on your interests. So this is how Facebook and Google make all their money. They track you across the web. They know your interests. They sell that information to advertisers, and then advertisers send you specific ads. When you're on Facebook, you may notice certain things come up more often than others or prioritized in your feed. That's based on the demonstrated interests, things that you've looked at while you're on the web. That they make more money by selling more personalized ads in that way. So it's very complicated and multifaceted now, and you have to look at the whole entire picture. And there's also ways that advertisers, this crosses over into privacy, which I'm not really going to talk about a lot today, but there's ways that advertisers get information about you and buy information about you and collect information about you that are sold by third parties, data brokers and the like. And the regulators are very concerned about that, how they're getting that information about you and where they're getting it from, and did the people who gave it give their consent?
So I imagine that advertisers typically have a compliance function that is looking at the ads.
Yes and no.
What do you mean by that?
So now you've got your major corporations, sort of the AT&Ts of the world. Huge compliance function, tons of lawyers in-house, very sophisticated, right? And I'll say that from personal experience because I do a lot of work with them. Then there are, smaller companies, startups, new entrants into the market that are less sophisticated. There are tons of them coming in every day in different industries. Some of them don't have the same compliance function. They're trying to do their best, but they just don't have the legal or commercial sophistication. And it's usually the last thing they do is sort of build up a compliance function around advertising. They think as long as they say the truthful thing, it's okay. And I'll give you a good example. We were approached a couple of weeks ago by a potential client who is selling a medical device which is very popular with old people. And these devices, if you go through Medicare and you buy it from a doctor, it costs thousands of dollars. They're very expensive, and sometimes Medicare doesn't cover it. So elderly people who need this thing will look for cheaper ways to get it. And so they're selling like a $100 version of something that you would buy for $300 or $3,000 rather. And it's very attractive, but it doesn't work as well. It just simply doesn't work as well. And it never will. It's cheaper. It doesn't have the right components. It doesn't work as well. And they've received investigations now from the FTC, for example. And the person who did it had all the right intentions, I think. That, his grandmother had this condition. He wanted to find something less expensive that she could get, and his heart was in the right place, I think. But you have to sort of stop and say, okay, why does it cost $3,000 on the one hand, and I'm selling it for $100? Is it I don't have the testing to support what they're saying? I can't say the same thing, even though he's trying to. He thinks it's as good as it, but he doesn't know enough to know what are the standards that a federal regulator apply to this. They need competent and reliable scientific substantiation, for example. So you've got to have clinical testing with a PhD at a university on a sufficient number of potential users, and they have to have a placebo and all these things that advertising lawyers know and people in the industry who are sophisticated know, but not new entrants necessarily. So,
and is that where most of these complaints come from? Is it generally the folks that don't have the compliance function?
Well, I would say the vast majority of cases in front of the state AGs and the FTC deal with those kinds of lack of sophistication cases. Now, you do see now and then a major corporation being hauled in. The most recent one, we're seeing reports of Facebook, for example, the $5 billion. Or Volkswagen, with the diesel engine issues. That was $4 billion plus a bunch of state investigations. So there are these sort of paradigm huge cases, but the vast majority of enforcement activity is occurring at kind of a lower sort of fraud level. And they're low-hanging fruit. I mean, they're easier to bring. They get bang for the buck. You get money back for people. You stop the bad behavior. It's necessary enforcement. Maybe not as sexy as some, but so there's that sort of dichotomy. There's this test cases that send a big message to big companies, watch out for us because we can bring the hammer down on you. But then there's a whole lot of sort of lower level fraud cases that get brought every day. And
what's the mistake that these lower level fraud guys make that brings them to the attention of some sort of regulator?
They don't think it'll ever be them. I think it's like a fish swimming in a school. They just hope that the shark comes through and the fish all scatter and they're not the one that gets swallowed. And many of them get away. Now, but then they inevitably get bigger. If they're successful, they get bigger, and that's when they draw the attention of the regulators.
Well, speaking of the attention of the regulators, before we get into some examples, of those mistakes, give us an idea of what the regulators' enforcement tool set looks like.
Very powerful. So, on the one hand, you have the Federal Trade Commission, which administers Section 5, Deceptive and Unfair Trade Practices in Commerce. A broad array of enforcement tools on that. They can get injunctive relief. They can get restitution for consumers, disgorgement of profits. They can shut you down. They can get asset freezes. Hugely powerful set of remedies. In fact, against the sort of common fraudsters that they're afraid of fleeing the country or hiding assets, they'll often go and get ex parte TRO. So, and I've had to defend some of these cases, and they're very, very difficult if you're defense counsel because you'll get a call and the FTC has come in and they put padlocks on the door. They've seized all the computers. They've seized the bank accounts, and this person is calling you from, I don't know, their car or their cell phone somewhere saying, I need help. And they can't even pay you.
And when you get that call, and assuming at some point you work out a compensation arrangement, what's your response? What steps do you take? How do you begin to analyze that kind of case?
In those cases, and frankly, I've been hired and then had to refer them to other counsel in some cases because we haven't been able to get paid. You have to go to the FTC lawyer and negotiate a release with some assets, and generally speaking, the FTC says, "Oh, that's fine. We'll pay you $150 an hour or something like that," which is not what a big firm lawyer could charge.
But let's
make a living.
Let's assume you get a client who can pay you, but they've got padlocks on their doors.
So
they've got this 30, 40 page complaint or whatever or accusation from the FTC. What do you?
So it's a classic litigation problem. So they'll come in with an ex parte TRO, and which means that the court will have already granted that TRO without having seen anything from the other side yet. So they have to make
And what's a TRO for those?
A temporary restraining order. Okay. So the two big things you have to show in getting a temporary restraining order is there's a liability. They're likely to be shown to be defrauding people or falsely advertising. And number two, there's harm, a lot of harm to people that can't necessarily be remedied. So those are the two big things. And the FTC will have already gone in and convinced the judge that this is a problem and needs to be shut down. And the judge will have agreed, at least as a preliminary matter, before they even hear from the other side. Because they're so concerned that the bad guys, at least as far as the FTC is concerned, have the likelihood of fleeing. It's like this guy in New York who's under investigation for sexual predatory behavior. They're keeping him in jail because they're afraid he might flee the country. That's a similar philosophy there. And in some ways, as a civil defendant, you have less rights than you would as a criminal defendant. As a criminal defendant, they would assign you a lawyer to defend the case. You could get a lawyer cost-free, but there's no such right to counsel for a civil defendant. So they actually might never get a lawyer and not be allowed a lawyer or a sufficient amount to pay a lawyer, depending on how bad it is. But if you're hired, what you have to do is you have to go into the court and convince the court that it's not as bad, or there are legitimate operations that can go on that aren't swept up in the alleged fraud, and that this company isn't all about defrauding people, that there's a product that has value, that people are actually working here. So I had one case in Florida where it was a bunch of call centers. This seems to be a big industry in Tampa, for example. In that area, there's a lot of infomercials and call centers and things like that. And a lot of people, that's their job. They work there. And the courts are concerned about that. They don't want to shut down and put 150 people out of work, even if they are answering phone calls or making phone calls. So you have to, make that argument that you're putting people out of work and there is a legitimate business here. It's not always the case that you can make that argument very well, but you have your work cut out for you to do it. And if you can, I think the courts are sympathetic to that because real people are affected.
So let me go back to one more question on these fraudsters, and then I want to ask you a couple questions about the competitor bit. I imagine that there is more of these low-hanging fruit type cases going on than actually are caught. What are the things that these people do that increase the likelihood that they're going to be the one that gets selected by an AG or the FTC for the pleasure of, employing you as their counsel?
Credit card fraud would be one. The credit card companies, one warning sign is when you get a lot of chargebacks. So people who are buying products through credit cards, if they don't like the product, they don't get it, or it doesn't live up to their expectations, may try to charge it back. And companies have to monitor that data. And so and the credit card companies themselves will report things to the FTC because they can be held liable or holding the bag. So that's one common area. The BBB, each BBB also.
And what's the BBB?
The BBB, Council of Better Business Bureaus. So there's one in every state, lots of municipalities. And I've actually used them. If you have a problem with a vendor or retailer, you can call the BBB or fill out a form online, and they will follow up with them. They'll write them a letter and say, please explain to us what happened here. And if they don't, the BBB will collect that information, put it online. They give companies ratings. But you'll see if you're going to enter into any kind of significant contract with a company you don't know, it's always worth checking that rating because they have A, B, C, D, and so on. And sometimes you'll see thousands of complaints against companies. And if that happens, then that also catches the attention of the regulators.
And I imagine sometimes you're unlucky enough to have sold a product to the elderly parent of the Attorney General. And that's another.
It happens. So I will say that I have, fortunately, I have a lot of friends over at the FTC, and I have heard of frauds and my elderly mother has been subject to fraud, and I have let them know. And I have seen things happen. So, and I'll tell you another funny story. The NAD, the National Advertising Division, is sort of a quasi-consumer regulator too. So they have these competitor versus competitor cases. But the NAD also has a portion of its docket where it brings what they call self-monitoring. And it's basically cases that they think are of interest, that there may be a problem. So they will on their own, write a letter to an advertiser and say, please provide us your support for what you're saying. Well, how do they pick those cases? The former director, Andrea Levine, who retired a couple of years ago, laughed because she said, she got them sometimes on an airplane picking out that in-flight magazine and flipping through it and seeing an ad that she just couldn't believe and then saying, all right, taking a note, and the next day in the office, sending out a letter.
So let's turn then quickly, if we can.
So never advertise in in-flight magazines.
Yeah, really good. That's one of the mistakes we'll take away. Let's turn to the competitor elements, and I'd like you to imagine a company that has a compliance function, that has people who think about not getting into, not having the pleasure of employing you as their litigation counsel. What happens? What happens when they end up on the wrong side of one of these things?
So I'll start with the NAD. The NAD is a self-regulation form. It's a voluntary. It is not litigation. It is sort of a boiled down litigation. There's a briefing process and meetings and so on. Then the NAD will issue a recommendation, and compliance is technically voluntary. Most companies, 97%, comply with those recommendations. You also have a right of appeal. If you don't comply, the NAD will refer you to the Federal Trade Commission for possible enforcement. And the FTC has many times said, hey, we take those NAD referrals, we put them on the top of the stack for when we're doing investigations. And now actually they've started reporting on every single referral they get, and you can go to the FTC website and you can see what happened. Most of the time they get closed, or the company gets sent back to the NAD or in some way or another. They try to resolve them without major enforcement. But every now and then they bring down the hammer. Then there's the Lanham Act, where, I've got a couple of cases going on right now. That's a statute with a lot of punch to it. So a competitor can sue another competitor in federal court. It's the same statute that deals with trademarks. And this one has a section of it that deals with false and misleading advertising in commerce. You can get an injunction. You can get damages. You can get lost sales. You can get disgorgement. You can get trebling. You can get attorney's fees. So very, very powerful set of remedies. As the plaintiff, you, of course, have the burden of proof. So there's really two hurdles you have to overcome. One is, what does the ad say? What does it really mean? There's what it expressly says, but a lot of time the action is, what does it imply? And how do you show what it implies? You normally do that with consumer research. And then there's harm, damages. That's the other big thing you got to overcome.
So when somebody ends up in one of these cases, what is typically the hard issue that the compliance group might struggle with that gets them there? What's the hardest? So
in any given company, let's say it's a big R&D driven type company, you're going to see a whole range of opinions on any given scientific issue. So, and this is true in lots of different fields. In product liability, sometimes somebody's written an email or a memo that questions, can we really say this? What's our evidence? Or they're poking holes. As any good scientist probably should do, you want that kind of feedback. Maybe as a lawyer, you don't want them to write it down. You'd rather have they just had it in a meeting somewhere. But very often it gets written down and sort of passed around. So you have to kind of explain that. And people take different views about how to support claims. So there's a whole range of things you can say about a product. Let's think about something that cleans a tabletop. How does it clean? How long does it clean? What kind of dirt does it clean? How hard do you have to press the piece of paper when you're wiping it down to test it? What kind of dirt do you use? There's a whole literature on dirt, believe it or not, like what kinds of dirt you use.
Did not know that there was a whole literature on dirt.
And sometimes there are industry standards, things like the ASTM, the American Society for Testing Materials. They publish standards on all sorts of different things. There's a European version of it called the IEC, International Electrochemical Commission or something like that. There's other entities like that publish standards, but so many times there isn't really a standard, particularly in new technologies that are evolving. A standard takes a whole bunch of scientists to get together over a period of time and develop it and then publish it for comment or it goes in draft, and it can take years to publish a standard. Meanwhile, technology is marching on. New things are being launched that there's no standard for. companies have to do their best to come up with a way to test it and prove that it does what it says it does. Or sometimes it does it better than product Y, And that's where the fighting happens, is this sort of newly evolving technologies. So in certain industries, you tend to see this disruption happening. I do a lot of work, as I mentioned earlier, in telecom. Constant change in telecom. New networks getting launched. You have, now 5G is launching worldwide. A whole new set of issues. But before that, there was 4G, and before that, there was 3G. There were different internet technologies. So we all used to be happy with DSL 15 years ago. Now people are routinely getting gig speeds at home. So all of these things, how do you measure that? Who has it? Where does it go? Who can access it? Under what circumstances? What are the limitations? And every company has a different way of implementing these things. And so there's lots of areas for potential dispute. Lots of areas for potential dispute.
Last subsequent question on this is, if you could give advice, 2 or 3, 4 things that companies you'd want them to do if they are not excited about being a defendant in one of these cases, what would that advice be?
How to avoid problems?
Yeah.
One is several things. One is pay attention to what's going on in the industry. If you look at NAD today, you could probably see different categories of things that are lots of recurrent players, recurrent complaints. Just take a look at what's happening there. Take a look at what the FTC, the hot button enforcement areas are there. For example, FTC in the States are very interested in financial fraud right now. There's lots of cases in that area. Mortgage fraud, financial fraud. Other hot button areas, opioids, Medicare fraud, things like that. They're recurrent issues. So those are high-risk areas. You've got to pay attention to those. Secondly, you need to, if you have the resources, obviously a compliance function, and it can't just be just a written compliance plan, but you have to implement it and monitor it and ensure that it's actually being followed. So it's great to have a compliance plan and be able to hand it over to the regulator when you get investigated, but they're going to want to know, well, did they follow it? And that's where a lot of companies tend to fall down.
One quick question before we let you go to the next section. So you're also a member of the Advertising Disputes and Litigation Committee, correct?
Yeah.
Can you just explain for listeners, why is that committee important in consumer protection law? What's your focus this year?
So we cover pretty much all the things that I've talked about during this podcast, but we tend to focus on the litigation side. So and we talk about compliance to the extent that it's a means to avoid litigation, I guess. We focus on FTC, state AG, and private litigation, whether it's class actions or Lanham Act. We have different kinds of content. Some we have policy-related content. Is the FTC policy right in this area, for example, would be an example. We try to further the law and create a robust discussion around, is this the right way for the regulators to be looking at it? Is this the right way for federal judges to handle these cases? Then we have a fair amount of content which is geared towards younger lawyers who may be starting out. And so it's sort of the 101 level courses where we help them learn the basics and also meet other like-minded people who range from lawyers in private practice to people at the agencies. And there's always this sort of cyclical, people go in and out of both. So it's a great way to just have a family or a network of people that are interested in the same things you do. They're interested in making the law better, interested in making the administration of justice better, and also interested in learning and advancing education and knowledge on these issues.
Chris, you obviously love practicing in this space, advertising law, consumer protection law. Why is that? What do you love?
Well, for one, it's relatable. Everybody, you can go to a cocktail party and everybody sees advertising. Everybody has an opinion about advertising. And so it's easy for people to understand. And yet it's a very robust, technically, intellectually challenging field. There's quite a bit of science involved, which is how I kind of got into it in the first place. So and it helps you tell a story. And the last thing I'll say is that for companies, advertising is an extremely fundamental, important thing. It's very close to the C-suite. So in many of the largest companies that we work with, the CEO is personally vested in the advertising dispute. And believe me, the CEO will be driving to the airport and see a billboard with something on it. They'll call the legal department and say, "Get that S down," and the whole legal department jumps, and that's when you get the call, and you have to act quickly. So it's very close, and that way you see how a company sees itself vis-a-vis its competitors, sees its strengths and weaknesses. So it's super interesting, and you learn a lot about companies.
All right, Chris. Well, let's shift gears a little bit. Tell us something surprising or unusual about yourself. Maybe if somebody doesn't know you professionally, something they wouldn't know about you.
So I used to be a marine biologist. So that's how I wound up in this area. And I started out with having every intention of becoming like a professor somewhere or teaching marine biology. Do
you know a lot about echolocation?
A little bit. I didn't study marine mammals or bats.
So what is your marine?
So I focused on coastal ecology primarily, and it's going back a ways, but I helped work on some of the earliest sort of fundamental research on sea level rise and the impact on the South Florida coastline. South Florida, like many subtropical areas, is protected by mangroves. You see that in Indonesia and Bangladesh, Australia, Maldives, and you have twin problems for mangroves right now: overdevelopment and just cutting of mangroves and replacement with hotels and condos and other things. And secondly, sea level rise. So they protect the coastline, and they protect in many of these areas the most fertile agricultural land is in near or just behind the mangroves. So we potentially face a real catastrophe if we both experience sea level rise, which is absolutely happening, and take away the mangroves or hurt the mangroves. So you could see pretty devastating impacts.
Pretty cool. Well, now it's time for our final segment, which we call The Curious Hat.
And now it's time for The Curious Hat.
Chris, in front of you is a camouflaged hat. There are a series of index cards in there. Could you pick out one of the index cards and hand it to me, please?
All right. Pick one right from the middle.
Okay. You've chosen question 21. What is your favorite hobby, Chris?
Cooking. I love cooking. I'm a avid amateur chef.
What do you cook?
Pretty much everything. I go through cycles. So right now I'm cooking a lot of South American and Mexican food. Probably depends on the season. So summertime I like cooking something like that. Wintertime I go more towards the Scandinavian.
How do you get started on this hobby? What got you interested in the first place?
I really like to eat. I think that's how a lot of chefs get started. Company. And when I first moved to DC, I lived by myself, and I had a kitchen for the first time, and I just started experimenting. And then I kind of found out it was a good way to meet girls, so I kept it up.
And how are you? How are you cooking things that involve chicken fingers, French fries, things like that?
No, I can get pretty elaborate. Although I'm not sort of a molecular gastronomist like some people are. I don't go to that level. But I do a lot of things that take multiple days, like broths and smoking and all the different things that require a lot of lead up. It drives my wife somewhat crazy, actually. Because she'll say, well, people over, she'll say, can't you just do something simple? And she realized I started 3 days ago.
What's been your most favorite reaction from someone else to your cooking?
Well, I found out that some of my really dear friends don't want us to come over because they're afraid they won't live up to the meal that I cooked. And I'm actually not picky about what I eat when I go somewhere. I'll eat anything, really. So I'm more about just enjoying company. But when I host, I kind of go a little over the top. But it's a hobby and it's a relaxing thing.
I have a similar problem with people not wanting me to come over, but it's for a different reason. And that will do it for today's show. We will be back next week with our next episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by the ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard and would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. If you have suggestions for topics or are interested in participating in a future episode, please reach out to us at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.